Hello, everybody. How you doing? Here we are today. Erekose, I'm Making a Murderer. Pretty special. We got Tracie Strunsee here today, special guest, along with Travis, of course, as we're going over the motion for post-conviction relief here, leading up to Kathleen Zellner's filing coming on February 1st, so that you guys can all understand what she's going to be talking about when she files. It's all based on this motion for post-conviction relief, and a couple like supplemental filings and that sort of thing, but we'll get to that in the last video about this. But anyway, that's what we're going over. So it's great to have Tracie and Travis here today. Hi, guys.
Hi.
All right. So the first thing we're going to do before we actually jump into the Q&A, guys, is to talk a little bit about something from the first video. Tracie was noticing something in the first video that she wanted to talk about concerning the statutes real quick. So I'm going to give her a chance to go ahead and talk about that real quick.
Okay, I just wanted to mention, when you first look at the petition for post-conviction relief, it says, the front page, it says that Kathleen is filing it as a 97406, thank you, as a 97406, which is the post-conviction statute, and 80515, which is actually a statute that asks for a new trial in the interest of justice. 80515 is actually a civil statute and doesn't apply in this case. So there are arguments at the end of the petition that she made in that, under that statute, but they really aren't going to apply at all. There is actually no, the circuit court has no inherent authority to offer a new trial or to overturn a conviction in the interest of new justice on collateral review, only on direct review. That's the only way that when they get time they can do it. We'll talk about it more when the time comes, but when we get to those arguments at the end of the PCR, it's still, or MPCR, you guys throw me off by adding that extra letter. When we get to that part, it's still important to pay attention to those arguments, because even though they don't apply to the circuit court, they actually will apply to the Court of Appeals. And those are arguments she can still make in her brief when she files the brief on February 1st. It'll just be under a different statute. It will fall under the, I think it's 75235 of discretionary reversal, because the Court of Appeals and the Supreme Court do have inherent authority to overturn a conviction in the interest of justice. The circuit court does not.
Okay.
That's all I wanted to say about that.
Okay. So it sounds like some arguments she made in the motion for post-conviction relief were made under a statute that they're not going to apply because the circuit court has no jurisdiction to rule on them.
Correct.
But she can issue those arguments under another statute with the appeals court that the appeals court can consider. Great. Okay. Yes. Okay. So that makes that clear enough.
So
okay.
It's still important. It's still important information. It's just going to be handled a little differently in the appellant brief.
Okay. It makes sense to you, Travis? Anything to?
Absolutely. And, you know, she's done a lot of things for purposes of non-waiver, like the motion to stay that was filed 4 or 5 days before the brief was originally due in December. It's kind of like, well, you know, it's additional testing and motion to stay, the appeal pending that. I think she does a lot of this stuff so that they can't come back later and say, you should have done it this way. Because when you look at some of these opinions from the 90s, and one opinion in particular that she cited in the early 90s, there was a lot of that going on. So, you know, who knows why she throws it in when it may not apply, but that could be one reason that they can't come back and tell her, oh, you know, you should have asserted 80515 in your brief with the circuit court, even though it doesn't apply. You know, we're sorry.
Right. So at least it's
so, you know, I don't know.
Case later for some reason. Okay.
Hey, I did.
I should mention that a lot of times when an 80515 is filed in conjunction with a 97406, the court just doesn't address it. They just ignore it, because the 97406 itself is the correct procedural mechanism to get a conviction overturned. It's
right.
Just that in that circumstance, it can only be overturned under constitutional or jurisdictional issues. So they usually, that's why it took a long time for the Court of Appeal, or actually it was the Supreme Court, to clarify this issue, because the only time that it really became an issue was in the 2010 case, State versus Henley, where they tried to file a standalone 80515. So there have been plenty of times where lawyers have filed both together, the 97406 and the 80515, and they just leave it because they're like, whatever, we can overturn it on the 97406. We're not going to even address the other stuff. So that's why there was a lot of confusion. The Court of Appeals actually certified that case, the Supreme Court, because as of 2010, even they were confused about it.
Okay. All right.
And Tracie's got some insight on how often the second district of the Court of Appeals, how often they actually grant oral argument and appeals. And she's been tracking statistically the length of time it takes for this appeal. And maybe we get her to talk a little bit about that, since she knows way more about that stuff than I do, being from out of state.
I know that you talked about timelines before. Obviously, they're impossible to predict, but after Kathleen files her brief, the state has 30 days to file a response. They will ask for an extension, whether it be 30 or 60 days. They will ask for one. It will be granted. And then she has 15 days to reply, which you guys said. The only thing is that Kathleen has said in an interview, and I know you guys talked about oral arguments being scheduled, and it's actually very rare in District 2, especially, for oral arguments to be scheduled. In 5 years, they've only granted only scheduled oral arguments twice in 5 years. 2 times in 5 years. That's it.
In criminal cases, right?
In criminal cases. It's not much higher for civil cases. Actually, there's 1 year where none were scheduled in either civil or criminal. So it's not much higher overall. I believe last year there were 3 civil cases and 1 criminal. So yeah, it's a rarity. So it really depends on whether the Court of Appeals feels like they need to have arguments in order to make a decision. But it's very likely they could decide that they're going to make the decision on briefs, which isn't a bad thing because it makes it go quicker. Because like as you said, it could take 3 to 4 months to get oral arguments scheduled, and a decision from the Court of Appeals could take 6 to even 9 months after that. So if they decide it just on briefs, that clock would start from the time that Kathleen files her reply, as opposed to waiting all the way till oral arguments are concluded. So it's not necessarily a bad thing.
Right.
So your best guess estimate, Tracie, late fall to end of the year?
Yeah, fall at earliest. I'd say late summer at earliest if they're being they just really want to get through this case. But fall is a better guess. And obviously anything can change if new evidence comes up and something more definitive comes up that can exonerate Steve. But if the appeal has to play out, then we're looking at late fall probably for a decision from the Court of Appeals.
Right.
At the earliest.
Yeah, like I said, I would say late summer would be a very generous guess, but it's possible. But to be on the safe side, I'd say fall.
I got a question for you then, Tracie, while we're here. So what do you think about the quick DNA testing on the bones? Okay, she obviously asked for the stay, didn't get it.
Right.
And everything. So now the appeals court said, well, you can pursue that separately.
Right.
But obviously, I think from listening to you, obviously when they meant separately, they meant after, right? Because she can't do it at the same time as she's running this appeal.
Correct.
That's right.
It's a separate procedure. It's a separate statute, separate procedure. There actually is no case law, no precedent whatsoever of anybody either trying or being denied the opportunity to file it in the circuit court while the appeal is pending.
Right.
But there are certain actions that are allowed pending appeal, and that is not one of them.
Okay.
The biggest reason would be that the Court of Appeals has jurisdiction. They have the record.
Okay.
So the circuit court doesn't really have the authority to rule except for in specific instances. While the Court of Appeals has jurisdiction, they would have to remand the case back or remand the record, even temporarily, back to the circuit court.
As they did, as they did when the CD thing happened. Right.
Correct.
Okay. So yeah, that makes sense. Then my next question is then, would Kathleen Zellner have sought assurances at the point of being told that by the Court of Appeals? Would she have sought assurances that she would be able to file that stuff later if her appeal just completely falls flat and she gets nothing, right? Do you think she most likely got assurances that she would be able to file that in 8-10 months?
She
Because
wouldn't
it's
have,
brand new when she filed it.
right.
It's not so brand new 8 to 10 months from now, right?
It wouldn't matter as long as it's brand new since the decision of the circuit court happened.
Okay.
Everything
So
that's
still be-
actually, technically everything she's found since the decision of the circuit court. Now she remanded it to get the CD added, but technically anything that she's found since then can be, if it is truly new, newly discovered, can be filed again in its successive petition for post-conviction relief.
Okay.
Now, when it comes to the scientific testing, that doesn't necessarily require another petition for post-conviction relief, because when she files the motion for scientific testing, if the results turn out the way she's hoping they do, when she files the motion, she has to say what she's hoping they will show and how that would be beneficial.
Right.
If the results come back in her favor, that automatically triggers a hearing. She does not need to file a successive petition for post-conviction relief with those results. She only needs to do that if she's planning on filing other grounds. But on the testing results itself, if those come back favorable, it automatically triggers a hearing.
Okay, so she'll be doing that later, but she'll basically be doing it under this same umbrella from this motion for testing.
Okay,
original?
so right, well, she would have to file a new motion for scientific testing in the circuit court at that time. Now, if Steve wins the appeal and a hearing is granted, she should still be able to do that. And if a hearing is triggered based on the results, then the court should just consolidate that hearing in with the evidentiary hearing that's granted by the Court of Appeals.
Once it's all sent back to the circuit court anyway. Right.
If the Court of Appeals denies or affirms the lower court decision and he loses the appeal and she loses in a petition for review with the Supreme Court, then she can still file that scientific motion because it's newly discovered evidence. It's new testing that's available. So she can still do that either way.
And she's bringing it as timely fashion as she can, obviously. So
Right. They can't say that it was around any earlier because it wasn't. So
literally those fires were happening in November and So it can't get any quicker than that, really. So so we have somebody that has a question here. It's from the slideshow earlier today. Somebody's asking about slide 39. Was Bobby Dassey sleeping between 3:30 and 3:45 p.m. on October 31st of 2005? I'll start off by answering this by saying that was from the defense's theory. That was Kathleen going over the defense's basically timeline of things, and the defense was very heavily stating that these events were happening between 3:30 and 3:45. That was really their narrative, and that's why they're claiming that particular part about it happening between 3 and 3:45. I don't think Zellner anymore thinks that. I think after the cell tower pings and everything, whatever, she's pinning everything down. She pretty much has all this stuff happening around 2:30 to 2:45, pretty much as the prosecution kind of laid it out originally. So just to make it clear, Janet, that is because that timeline is from the defense, and it's probably not very good. The bus driver definitely didn't see her on the 31st. She may have seen her on another day, but not the 31st. I know Carla, Stephen's niece, told me that they would often put cars out by the Avery sign, and certainly the bus driver could have seen somebody taking pictures of a car at the Avery sign, but they definitely could not see pictures of Teresa taking pictures of a car way over by Avery's trailer from where the bus drops off. It's just not possible. So anyway, so that's what that was about. That was the defense's timeline that they thought things were happening back then in 2005. Any thoughts from you guys on that?
No, I agree. We were just kind of summarizing Zellner and her MPCR sets out, the state's case at the time of trial and the defense's case at the time of trial. The state's case she laid out so that she could poke holes in their narrative so that she could undermine confidence in the verdict. And then I think, she lays out the defense's theories because she's going to need to address certain things, why she thinks things were, why there was ineffective assistance of counsel, IAC. So she has to lay that out. and she's got to lay out enough of a narrative to set forth her 3 Brady claims that she's got. So we're just summarizing her summarization, so to speak.
Right. Yeah, exactly. Condensing it a bit. So let's see here. This one ought to be good for Tracie. Captain Crunch asks.
Oh gosh, is that Paul?
That's the Mad Scotsman, of course. Yes.
It
Will
has to be.
KZ wait till the 1st of February and file at the last minute?
Yes.
That's what I thought you'd say. And the reason being is because most lawyers want to wait until the last possible second because you never know what crazy development might happen.
Just
right?
in case something else comes up. She may file a day early, but I mean it's standard procedure for lawyers to wait until the last minute.
Time she's been given, right? Yeah. Yep. Let's see.
What's the weather? In places I've had to practice where, where I've been admitted out of state for limited cases, where the weather is a real big issue, you do fly in a day or two ahead of time. What's the weather up there in Waukesha in early February?
It's Wisconsin. It could be 60 degrees. It could be sub-zero with 12 inches of snow.
Okay.
You don't know.
So,
but the briefs are filed electronically, so it's no issue there. But sometimes they usually file a day before, sometimes just in case there's any issues with signature pages and formats or anything like that. But otherwise they file on the day of. Sometimes they file at the day, like they will file it the day before, but it won't show up on the docket until the day of too. But
now, is it the circuit courts that are still, you file a hard copy, or are they getting more progress? I saw something in where she tried to file something electronically and it wasn't received.
That was the motion to extend time. Motions to extend time have to be filed. They have to be faxed or mailed, one of the two, but they can't be filed electronically. Only the briefs can be.
Now, does she still have the option to file hard copies, or you're not allowed to file? You can only electronic file now.
I do believe you have to submit hard copies, but as long as the actual filing is in the court system on the day of, they electronically file, and then the hard copies get there whenever. Yeah. But they still have to file like a stupid amount of hard copies, like 25 copies or something like that. It's ridiculous.
Yeah, I agree. Wait until the last possible second until, you just never know what happens. Who knows? Colburn may accept her cabinet challenge. Then what will we do?
I mean, nothing's for certain, but, Kathleen has never filed anything early. So I can't imagine why she would do it now.
Right. Yeah.
Especially when we're only, a week and a half away or whatever. Or I don't even know. What day is it? Yeah, a week and a half away, basically.
Okay, so Denise asks, in terms of slide 40, Stephen behaved like an innocent man. How much weight does this carry in court? I'm going to take a shot at answering that real quick by saying I think it matters in a sense, and even might matter to a jury in a sense. But the problem is the weight of the evidence that Stephen has kind of against him. It kind of, I think, makes that kind of circumstantial evidence of, well, he seems like he's acting like an innocent guy. It makes it less powerful. Now, granted, we all have issues with a lot of this evidence, and we feel it was doctored or planted or, not, it just doesn't seem right. But the fact of the matter is it went into a court of law, it was made fact, and it was used with a jury, and they convicted. So that's where we're at. And it's like Travis keeps, bringing up in the PowerPoints and everything, it's all about undermining confidence in the verdict at this point. That's the game. That's the name of the game. That's what it's all about. So you guys have any thoughts on that, about his behavior seeming innocent?
Are they referring to how his behavior is now?
I think what they were referring to is the fact that if he was truly had done this crime, why didn't he get those bones cleared out of his pit or the Yonda burn barrel? Why you know, why would he have left after the media started showing up on the 4th and 5th and stuff? Why would he have left those cell phones and those things in his burn barrel? Why? I mean, he acts like a person who had no idea what was happening. And so people are saying, should that stuff kind of matter at all?
Those types of things are what's considered factual issues. Those are things that what a jury decides when they watch a trial.
Right.
The Court of Appeals does not deal in factual issues. They deal in legal issues. They give a lot of, this is why they give so much deference and under standard of review to the circuit court, because the jury and the judge are the triers of fact. And the Court of Appeals is dealing strictly with matters of law, unless it's a discretionary decision, which this is, if the facts are not supported by the record. Like when the judge said in her opinion that Kathleen made no arguments showing why he should be able to present another 97406 when he already had presented one, that is an error of fact. That is not true. The record does not support that factual claim. Right. So in that case, then the Court of Appeals can overturn a decision on a factual claim, but otherwise they are usually dealing with matters of law. And so credibility of witnesses, whether you believe the logic behind the theory, everything, that is all a matter for the jury and is really not given any weight in the Court of Appeals.
Right. Okay. Let's see here. Somebody's asking, slide 4, did law enforcement get pictures of the scratches on Bobby Dassey, supposedly from the puppies? Yeah, I've seen pictures of it. I don't remember that being mentioned on slide 4, but slide 8, hold on. If there was a violation of Stephen Avery's constitutional rights, why can't KZ get him out on a new trial for that alone? Well, she's making a case for it. That's what she's doing. I guess that's my best answer to that question. You guys, I mean, that's what she's bringing, right? Constitutional. That's what the Brady violations, you know, and all the things that she's bringing and arguing. That's what they are, right?
Yeah, it might be that ends up that she gets a new trial based on that issue alone. But and Tracie's done a great job of explaining this in her Facebook videos that I've had an opportunity to see. You have to bring all of this together. You got to bring it all at one time. Otherwise, you've got to show, if you file a subsequent one, that you didn't have that information available. So Kathleen has to bring in her brief every conceivable basis for either an evidentiary hearing or a retrial at one time. So that's undermining the confidence of the verdict. That's constitutional claims, whether it be Brady or IAC. So, you know, that's why she's got a very, very comprehensive motion. How it turns out, what it ends up being reversed on, or what it ends up being sent back for a evidentiary hearing on, it could come down to just one issue or multiple issues, but in theoretically, all it takes is one Brady violation to get a new trial.
Right.
Tracie, do you have anything to add on that?
No, it's just that the 97406, like I said earlier, is strictly addressing constitutional issues. That's everything she's filed is considered a constitutional issue according to what she's presented. It's up to the court to decide whether it actually is or not. And that is where the statutes come in, the case law comes in, and she provides supporting evidence of these things, but it's really ultimately up to the court to decide if his rights were violated in any way with any or all these claims. But as Travis said, she only has to win on one.
Right.
She's filed about 60 claims overall, I think, and she only has to win on one of them for the conviction to be overturned.
So I guess that's your answer, Kelly Merritt, is that's what's in process. That's what's happening right now. That's the arguments that are being brought. What's frustrating about it is that Judge Angela Sukowicz is being deliberately obstructive. Or at least that's my opinion. I'll package it in that little bow. That's my opinion. that she's deliberately obstructing this. So that's having to go to the Court of Appeals. But that's basically what's on the plate. That's what's happening. Brady violations, ineffective assistance of counsel, you know, every tool that a post-conviction lawyer has to use, she's pulling every tool out of the tool chest and using it.
I use
so
I use the very legal technical term when I say that she's dumb. The judge is dumb. That's it. I say that. You've seen me do my videos. I have no better way to put it. She's just dumb.
She's definitely a legal lightweight, and evidently they love her in Sheboygan. Didn't even have an opponent. Got another 6-year term to
terrorize people.
Well, no, they must love her there. You know,
just because nobody ran against her?
Yeah, people don't know any better. They don't, you know. Unless you've actually been in front of her, then nobody cares. They don't. It's unfortunate. That's how, I mean, most of our Court of Appeals judges ran unopposed as well.
Yeah. Well,
so how much can you change when they run unopposed?
Yeah. Yeah. It's yeah. Politics is creeping too much into our criminal justice system, I think, but that's for sure. Okay, so Christina Townsend asks, I think it was in slide 31, how do we know DNA on the key came from the toothbrush? That was the defense's theory, wasn't it? Oh, no, that was...
That's defense's, and they argued, And so, again, Kathleen is summarizing what the defense team presented at trial and argued to the jury, and that was their theory as to how the DNA would have gotten there. And we know now that Zellner, through her experts and investigators, has come up with a different way for that to have occurred. And it's actually going to be a later segment that we're doing on this series on the MPCR about the groin swab, but we'll get to that in an episode or two.
Okay.
And that's a good example of why she laid this out. She's going to be talking later in the brief in this motion about, you know, they should have come up with other theories. They should have been able to discover, like we were able to discover, that this groin swab probably comes into play.
Right. The groin swab, yeah. Somebody asked an interesting question here. So is the basically, is the CD the only possible Brady violation? So I know the answer to that is no, because I was just rewatching MAM2 the other day and was listening to Zellner talk about the fact that if, you know, Kevin Ramlow's account of telling Officer Colburn that he saw the RAV4 over by the dam, basically, or whatever, that the fact that there's no report about that, she's, I guess, going to make the argument, and I'm going to love to hear Tracie's take on this. She's, I guess, saying she can make the argument that that is a Brady violation because that is a report that should have been made, that should have been something that the defense knew about, and I guess she may try to construe that as a Brady violation. What do you think about that, Tracie?
You should probably already know my opinion on these things.
I think I do, because I can tell by the way you folded your...
Well, it has to be proven it's a Brady violation. In order to do that, she has to prove that this actually happened.
And it's just Kevin's word against
It's just
Colburn's
Kevin's word.
right now,
This
right?
is the type of thing, though, that requires an evidentiary hearing.
Right.
This is why you have an evidentiary hearing. The same thing with the toothbrush. It's essentially a theory that she's presenting, but it's not absolute fact, and it's something that needs to be further assessed, evaluated, critically examined during a hearing.
Right.
That's why you need to get Colburn on the stand, and then you need to try to get him to screw up and say something that he, you know, to prove that he was there, he did hear this. Then it could be a Brady violation. But until we know that this actually happened, or that Colburn actually even didn't do anything like she's claiming, you really can't say that it is. It's potentially one. I think that's going to be a tough one to prove, unless you can get Colburn on the stand to admit that he remembers Kevin Ramlow and that he didn't write a report, which is very, slim that would happen. But Yeah, I mean, the Brady violations are, a lot of them are dependent on getting somebody on the other side to admit something wrong. That's
I find
hard.
Kevin Ramlow's account credible.
I find
I
him
mean-
credible, and I think the fact that there is evidence of him texting Scott and telling him about it
Yeah.
is even more support of that fact.
Yeah.
But again, it still needs to be further examined.
Absolutely. Oh, I'd love. Yeah, I'm right with you on that, Tracy.
Yeah.
This stuff needs to get into a room where both sides can sit there and pick at it, and then we'll see what stands. What's
Right.
left standing after both sides pick at it is going to be pretty darn close
Right.
to the truth.
Everything
so.
sounds good depending on the side when you're only hearing one side of the argument or you're including theories in there. And that's a lawyer's job, is to make it sound good. But we have an adversarial system, and that means that you have to have the right to cross-examine. That's why it's so important to get a hearing. We need to get Fassbender on the stand. We need to get Kratz on the stand.
Yep.
We need to get Wiegert on the stand. We need to get all of them on the stand, because that's where we're going to start getting to the truth.
Yep.
Kathleen is going to have to make them slip up, make them trip over their words, make them say something wrong. And that's where you strengthen the case.
Yeah, absolutely.
So the four Brady, she alleged three in her brief, again, which we're going to come up on, but one was they concealed the information about the gasoline remaining in the RAV4 so that they could compute how far she traveled that day. The second one is the flyover video was edited. The third was investigators concealed their knowledge that Ms. Halbach's RAV4 was driven onto Mr. Redaunt's property, and then since the time of the filing of the MPCR, we know that the fourth one is the computer. So those are going to be the four that are still in play, and then to what extent, we'll have to wait until February 1st to read her brief.
Right, and see what she argues.
But Tracy's absolutely right, unless you get, and that's what the evidentiary hearings were all about in Brendan's case that you saw in MAM2. You saw Lynn up on the stand and the investigator up on the stand. Stephen had an evidentiary hearing that was conducted by Willis very early on when he had his court-appointed appellate counsel. And yeah, you're able to get those witnesses, get them up, cross-examine them, and flesh out whether there's an actual Brady violation or not. But if you have a judge that's not even willing to go to the effort,
right,
then maybe Tracie can explain, to deny the motion. Judge Angie had a standard she had to adhere to, and Tracie's up on that, but it'd be good for her to explain the standard. In order for her to not make findings of fact and conclusions of law on all these issues in this motion that we're going through, Judge Angie had to reach this high standard in order to avoid that. And she made this finding that the motion that we're going through now is either fundamentally flawed, late, or just as a matter of law was groundless. What's that standard, Tracie, that the statute says the circuit court judge will make findings of fact and conclusions of law unless, and then it's that they find that the grounds raised by the applicant for post-conviction relief basically just hasn't stated anything.
Right. The two biggest standards of review that are going to apply to this case are the erroneous error and discretion standard review and de novo standard review. I think everybody knows by now that de novo standard of review is dealing strictly with questions of law, and they give no deference to the judge's decision at all. It's like it doesn't even exist. The erroneous exercise and discretion standard of review says that you're going to give a lot of deference to the circuit court because she was the one that like I said, is the trier of fact. She's the one that's to determine what is factually correct. But they can overturn it if they determine that there was, like I said, a misstatement of the facts, or if there was a misapplication of law, of a legal statute, legal proceeding, whatever you want to call it, legal standard. That's what I was trying to think of. So in some of the things she said in her decision, I said the two biggest are the first one when she says that, wow, I'm totally drawing a blank right now. Oh, okay. Well, one of them was that she said that Kathleen made no arguments. I just mentioned it before, made no arguments showing why Steve should be able to file another 97406 when he'd already previously filed one. He should be procedurally barred, and Kathleen would have to show or present arguments saying why he should be allowed to file another one. When the court said, or when the judge said that she made no arguments, that is just a clear error of fact, because Kathleen actually did make arguments saying why she should be allowed, or Steve should be allowed to file another one. She said that he did not possess the legal acumen in order to make basically a good showing in his petition, that he didn't have access to his entire legal file, that he did not have the resources nor the money to hire the experts to be able to find the things that she did. And she mentioned a few other things in there. So for the judge to say that she presented no arguments is just factually incorrect.
Oh, so many things that she said just seemed like she was looking at something completely different than I was.
And then the other big one is when she said that Kathleen needed to file ineffective assistance of counsel claims in the appellate court under a Knight petition. That is true when you're filing IAC claims against appellate counsel. But again, Kathleen was very clear in her petition that she was filing it against his appellate counsel, but in their capacity, or in their post-conviction capacity. When you're filing an IAC claim against post-conviction attorneys, it's filed in the circuit court, which is what she did. So that's an error of fact and an error in law, and a misapplication of law. Because no, she doesn't file a Knight petition because she, like I said, she's not actually saying that they were ineffective in their appellate role. She's saying that they were ineffective in their post-conviction role. And so that's another mistake on both fact and law. And so I don't know, does that even answer your question, Travis? I'm not sure exactly where you were getting at, but does that sort of answer what you were saying or asking? I get lost in my own, like when I'm thinking about these things. I do get lost in my own head.
I wanted you to explain what, she had to do in order to deny, you did answer it. Absolutely.
All right.
I mean, obviously there's a lot more, but those are the two big, I said before we even went on the air, it's like, how can somebody get so much wrong in 8 pages? Because she made factual errors when discussing the findings of the experts that Kathleen had to then try to correct her on in the motion for reconsideration, in the motion to vacate. So it's like essentially she had like 4 reasons for Kathleen denying this, and they were all wrong. So
right. Yeah. Crazy. Yeah. Judge Angela, good old Angie.
You gotta love her.
Okay, this person asks, Erekose in slide 4 mentioned the expert to look at Ryan Hilligas's scratches, or actually the bruises. He was an MD who was going to weigh in on the bruising on his hands. Wondering if that same expert looked at BOD scratches. I don't know that he did. As far as I know, that expert was only going to be looking at pictures of Ryan Hilligas's hands. Don't know if he actually got his hands on Bobby Dassey or which doctor. I think, if I remember correctly, Bobby Dassey was taken down the same time as Steve to a medical facility, and they were looking him over at that point on the initial days of the investigation, if I remember correctly. And they took pictures of it, but I don't know that anybody actually other than that physically looked at them. It's only pictures at this point. So I don't know the answer to that, if that guy is going to be inspecting his scratches, I guess is what I'm saying. Let's see, any more questions? Okay, slide 31. Could the defense not request the cabinet to be brought into the courtroom? I get this question a lot, guys. So let's have the two legal minds go at this and explain what Jerry and Dean would have needed to do to bring it into court if they could or couldn't, or were barred in some way, or why Kratz and crew didn't bring it into court, or if you guys want to just kind of expound on that a little bit.
I have a probably way more detailed answer than you want. Gosh, I don't even know how to explain this. Any type of scientific expert, any type of experimentation has to be approved by a motion prior to trial. You can't just, it's not like the movies, like, where you watch like a courtroom drama and they just drag in something. It's not like that. You have to file a pretrial motion in order to admit any type of expert testimony and any type of expert, like I said, experiments.
I'm surprised they didn't do that.
Well, yeah. Well, I'm not surprised that Jerry and Dean didn't do any, nothing surprised me anymore what they didn't do.
Do you feel like they were kind of phoning it in at a certain point? Is that what you're saying?
I'm sorry. There's a reason there are 50 IAC claims, and a lot of them are valid, so.
I agree. There should have been more experts on that. I am 100% in agreement. So.
And, from watching my videos that there's some case law that helps in that area too, which I hope Kathleen adds, but that's another issue.
Right.
So here's where it gets interesting, is because a lot of people have probably heard of the Daubert standard. Okay, that was the U.S. Supreme Court case where they basically set the rules for what can be considered a legal expert or like scientific expert, or what can be presented as scientifically sound in a trial. I believe Daubert was in 1983. Wisconsin, in all of their, brilliance, didn't adopt it. They went with something called the Wallstad rule instead. And this is exactly why the EDTA testimony was allowed in. Because under Wallstad, it was a very forgiving standard. All you basically had to do was say that you had to show that the person was qualified as an expert in their field. Not hard to do if you're working in the field.
Right.
And that whatever information they were going to provide would be helpful to the jury in making a decision. That was it. There was nothing in Wallstad saying that the science had to be scientifically sound, that it had to be generally accepted by the scientific community. It didn't have to be peer reviewed. Nothing that was required under Daubert. And the state of Wisconsin didn't adopt Daubert until, I believe, the early 2000s, or maybe it was even, the late 2000s. It might have been like 2009, 2000. Yeah, something like that.
I was gonna say, it had to be after 2007, right?
Right. So under Daubert, it would probably not be allowed to bring in the case, because it is, no matter what, you can't say for sure that you're exactly replicating the circumstances. Under Wallstad, they might have been able to squeak it through because they squeaked in the EDTA crap. That's just junk science. That EDTA stuff would not be allowed in a court today.
Right.
It would never be allowed. But it was
seems
then.
like it never works out very well. It didn't seem to work out very well with OJ. It didn't seem to work out very well here.
Yeah, I'm disturbed that, I think Daubert was actually 93. Did I say 83? I think it's 93. Essentially, the state of Wisconsin went 18 years of criminal trials, where junk science was allowed in.
Right.
So trust me, it's not only Steve's case. I'm sure I'm actually frightened to know.
That's probably why there was 900 of them knocking on the door after Steven got released.
Right. And that's the thing in Steve's first case. Once it was determined that the hair comparison science was junk science, he wasn't granted a new trial, but that's why he was allowed to test that pubic hair. If that hadn't happened, he might not have even been allowed to do that DNA testing.
Right.
And he could still be, or he would have been released by now on that, but he never would have been exonerated on that. Right. So it's kind of sad that they convicted people for almost 20 years on essentially a lot of junk science, and there's no recourse for it. You can't go back and be like, well, that shouldn't have been allowed.
Right.
They might let you retest something, but they won't overturn a conviction because of it. Mm-hmm. Trust me, I talked to Zellner, or I emailed Zellner about it, because I was like, can we retroactively complain about the EDTA, even though we know that it's actually not important? But still, he was convicted on junk science, Yeah. That was part of his conviction. But yeah, not much you can do about it.
That's kind of one of the things I'm kind of excited about Jerry and Dean's little CIFS. I really hope that kind of catches on, because that would really, really kind of reinforce and bring more integrity to the forensic sciences in the courtroom. I think having, organizations like that setting kind of a standard, and that sort of thing, and advocating for it. So I don't know. I'm hopeful for them on that.
Yeah, I agree with that. And we saw that with there's a little clip in 1 or 2 about they're getting ready to drop keys on the courtroom floor, and it's just a demonstration, and what they're talking about is a courtroom demonstration, and yeah, that's absolutely right. You got to bring a motion. So when people refer to the bookcase or whatever it is where the key allegedly sprung from, they usually ask it in the context of using it as for a demonstration, and that's absolutely right. You can't spring a courtroom demonstration. Everybody knows the most famous. Everybody knows the most famous courtroom demonstration in the annals of U.S. jurisprudence. You can just say it right now, and someone's going to type it in your thing. And it was the biggest utter failure on the face of the planet. You don't do in-room court demonstrations because the glove won't fit, and you got to acquit.
Right.
And so, but in terms of why didn't they bring it in? Just to bring it in, either side could have brought that in.
They just had to do it before trial.
Here it is. This is what it looks like. Now, having somebody touch it and do something with it, that's a whole nother thing. Right. But again, earlier, what we were saying is during closing arguments, the defense said, look, they're in possession of that cabinet. They didn't bring that in here. Why is that? It's a common thing to raise reasonable doubt. Why didn't they bring that in here? They could have brought it in here.
Right.
They could have showed you what do they have to hide, but you got to worry about the state getting up there and rebuttal and saying they had the same opportunity to bring it in as well. What do they have to hide? So
right.
They did raise it that the state could have brought it in, and they didn't. Now, why didn't the defense bring it in and do a courtroom demonstration? No one wants to be the next. They didn't want to be the example for the 21st century that Christopher Darden.
Yeah, they didn't want to be Chris Darden.
Yeah.
Poor guy.
That's why you don't.
Chris
That's
Darden,
why you don't do courtroom
I
demonstrations.
guy, actually, but anyway. But
you have your investigator do it and video it, and then come in and testify about it. You never do it in the courtroom.
Right in front of them, right? Yeah.
Right, and it never would have been allowed if it hadn't been. If Johnny Cochran hadn't tricked Chris Darden into being the one to ask for it.
Right, exactly, right.
So yeah, if people want to know why that wasn't objected to, well, it could have been, but the state's the one that actually asked for him to do it.
They tricked him into suggesting it. I mean, it's...
And then the defense was just like, sure, why not?
Okay.
Yeah, so...
They had led him to believe that they were like, oh my God, no.
Like, we don't want you to do that.
They're like, oh yeah, let's do this.
Yeah. It was like Travis said, probably one of the biggest boneheaded mistakes ever in a courtroom.
Yeah. So, somebody asks here. Philippe Artista asks, "I heard that Brendan's confession was not used against Stephen Avery in his trial. Is that significant?" It's honestly, for me, it's significant. Let me ask you this: had the confession been introduced in any way at trial, wouldn't that have opened up Dean and Jerry to just absolutely just pummel the state in terms of, picking apart Brendan's confession on the stand? If they were able to get Brendan on the stand and just, obliterate, that whole entire thing and show where most of this narrative came from and how ridiculous it is and how it was suggested to Brendan 98% of the time.
It would have been clear grounds for reversal if they would have let the confession in. There's lots of Supreme Court case law on that since the 90s. I was involved in a real huge case in Austin. It's called the Yogurt Shop Murders, where they allowed the confession of a co-defendant who, the cases were severed into 3 different cases, three co-defendants, and they allowed the confession of one co-defendant, a juvenile coerced into a confession. They allowed that into the trial of the other, and went up to our highest court, which is the Texas Court of Criminal Appeals. And then during that time, the Supreme Court said, you cannot do that. That's a fundamental violation of due process. So, but they didn't really need to, did they, after that press conference?
Right. Yeah. I mean,
No.
yeah.
No, but I don't know if Tracie has a different viewpoint on that, but the case law I've seen since the late 90s has been abundantly clear. You can't let in anything in terms of a confession. Now, if the person who confessed comes into court and testifies against you, which is what was going on in this case up until the day before trial, they can cut a deal, come in, testify against you, and you're able to cross-examine them and try and show that you made a sweetheart of a deal, and
I guess that's what I'm getting at.
Yeah.
Is that the prosecution would have had to introduce Brendan in order for the defense to really.
Yeah, it would have been it would have been hearsay otherwise. It's inadmissible hearsay unless you can get Brendan in there to actually testify and they can confront him with their own questioning.
Okay.
It was still dangerous because they knew none of the physical evidence matched Brendan's confession.
Right.
Brendan's own words could convict him in his trial, even though the crime scene didn't match the confession. But in Steve's case, Steve isn't confessing to this crime, so they're going to introduce something that completely contradicts the crime scene and the crime, the forensic evidence. Right. It would not have been good for them to think about introducing Brendan's confession. Not to mention that Brendan had recanted, and so they also didn't want to put him on the stand in Steve's trial where he was going to recant his confession on the stand.
Exactly. Teen and Jerry would have just teed off. If they had tried to put him on the stand, Teen and Jerry, it would have been like, oh, the angels singing, kind of thing. They would have just been able to just line by line rip that entire confession to pieces and show it for the piece of refuse that it is, So,
well,
certainly,
as a practical matter, if a deal's not cut and he's still a defendant, his trial came second. They weren't going to call him. He's represented by counsel.
Right.
The counsel would have come in and said, hey, what are you guys doing here? Well, Judge, they named Brendan as a witness. What's going on here? Are we going to go through this charade of putting Brendan on there and make him take the fifth? Which many courts, I don't know what they do in Wisconsin, but they don't even let you go through the charade. They weren't going to call him if he hadn't made a deal. He's got
sure
all of those rights attached. So it really doesn't work that way. The DA calls you up if you have a co-defendant that's severed into a separate case, says, look, I'm going to send your client a subpoena. Let me know if he wants to testify or not. And we just tell them, nope, they're going to assert their Fifth Amendment ground, and they send you a letter back. Okay, I'm not going to require them to appear. The most they can do in Texas is clear the courtroom. Defendant gets up, gets on the stand. They ask, first question, what's your name? Based on the advice of counsel, I freeze to answer that question on the grounds it may incriminate me. Do you intend to answer all the following questions I have the same way? Yes. Okay, that's the most they can do. Then we all leave, and then the jury gets called back in.
Mm-hmm. Right. Okay. Okay, Jamie Hart asks, can any of the people who were involved, who were basically involved in the first trial and stuff like that, who are obviously still living, can they in any way deny a subpoena if they're subpoenaed in a second trial, if that were to happen, or even in an evidentiary hearing?
No.
So
you have to appear. You have to appear if you're subpoenaed.
Okay. Unless they have maybe some kind of weird bedridden kind of circumstances, there might be maybe some wiggle room there.
If it's Zellner, she would still find a way to get
Right.
there in the court, you know, yeah.
So
Even if it
okay.
was by video, whatever. I mean, like, yeah, I mean,
So one way or another. Okay.
you have to, yeah.
Well, and it's funny, or not funny, but in Wisconsin, you can appear by telephone in a criminal case, which that's interesting. We have that, of course, in civil cases in Texas, but we don't have that in Texas.
For criminal cases, you mean?
Yeah, I can't remember which state it was, but recently there was a case where a woman testified in her own murder case because she was on death's door, and they got a statement from her on video before she died, and it was ruled that it could be used during her trial. So it was like the first case of anyone ever testifying in their own murder trial. I don't know if it'll stand up on appellate review, but it was interesting. I was like, wow, never heard that before. But it was a video testimony in the hospital while she was.
Right. I think I remember hearing something about that.
Yeah, it was weird. It's just a strange case. Never heard of that, but heard of that before.
Right. Okay, so here's a good question. Jeff Correa asks, if Stephen gets a new trial, does the state have to do any special maneuvering or whatever based on the fact that he was found not guilty of mutilating a corpse? I guess when it goes to retrial, will that charge be able to be brought against him again?
He was acquitted. He was acquitted of that charge, so he can't. That double jeopardy would apply.
Okay, so that's
forever barred.
Yeah.
Okay, great. Oh, damn it. Sorry, looking for another one here. If we get a retrial, can the defense call Brennan as a witness? Can they, and would they want to?
They could, but they would not.
Yeah. It's like what you were saying, because it would all be hearsay essentially, because right. It's up
a new trial.
So to answer that question, guys, the prosecution needs to bring Brennan into court in order for the defense to really be able to dig their teeth in on it. But if they try to drag Brennan in, it's not so good.
Right. In a new trial is starting over, completely over. They can call any new witnesses. That's when they can change their narrative, because there's been some questions about that came up when Kathleen wanted to do the testing of the bones. Some people had said, well, why can't the state just come back and say, like, well, she was moved over there, or someone said that Brendan's confession, mentioned the quarry. You can't change your story after you've already had a trial. You got to stick to that all the way through. Now, if his conviction was overturned and he was retried, then the state is welcome to change their theory, their narrative, their entire theory of the crime, because it's starting over. But they can't do it now.
Within the confines of the previous testimony under oath. So Colburn,
that can still be used. Yes,
he can't change his narrative.
Well, he can. He can try.
But they're locked in under oath. But within the confines of that, they can say whenever and whatever. They can accept 100% that Zellner's new evidence is absolutely acceptable, that it's credible, and then they can create their own new narrative to show that what Kathleen has developed scientific-wise somehow fits into their new theory. But it's completely new. Everything starts all over again. However, everybody is subject to cross-examination, impeachment with their prior testimony under oath.
Yeah, absolutely.
Okay. Let's see. Tony Frattini asks, does anyone know if the DNA profile belonging to CX found in the quarry has been run through any DNA databases? Now, that seems like a question for Scooby. I don't think it's been run through any databases. Do you guys happen to know if you've heard of that?
It was run through the state database at the time, but I don't believe it's been
not like coded.
Right. It wouldn't have any reason to be run again.
Yeah.
I mean, Kathleen might want to, but the state would never run it again for any reason.
Okay. So it's been run through the state's database, but not CODIS with the FBI, most likely. Then is what you're saying.
Well, it might have been run through CODIS at the time. We don't really know, but I just don't think it's been run since then.
So it's just not a match
So,
at this point, right?
Right.
Okay.
So if they ran it again, it certainly could be a match of something, but and that would be another thing that would be allowed. If there was a new trial, then Kathleen would have the right to get that run through again. Because then she has access to all the evidence and she can do whatever testing she wants at that point again. So that's something that could also happen.
Yeah, absolutely. Just see.
And that's something that if she got an evidentiary hearing, not even a new trial, but depending on the grounds for the evidentiary hearing, she could have apply to the court, the circuit court, to have stuff run. But it's going to depend on the judge and the grounds for an evidentiary hearing if she's given one, what issues.
I think that's why because since the evidentiary hearing does have a limited scope, I think that's why her arguments in a motion for scientific testing would have to be very strong for them to allow something like that. She's not going to be able to test anything she wants, but she has to have some very good.
Yeah, but CODIS isn't scientific testing, so she can ask that outside the scope of new scientific testing. It's like running prints through APHIS, and you can get a judge to allow you to have.
Not if it's Angie.
Print. Well,
hopefully she'll be gone at that point. Yeah.
Yeah, but having prints run, these 8 prints and other things,
right?
As part of an evidentiary hearing, you can ask a judge to require the state to do that because it's not scientific testing, and so it's outside the scope of that.
But if she wanted to run the sample of that through her own experts, which they wouldn't have access to the databases. So
then you're,
yeah, but that would be, yeah.
But CX, since that's got a state lab ID, I'm assuming you don't have to have the item. You just, with CODIS and APHIS, you can do it with photocopies, and CODIS, you just type in the markers, so you don't have to have the specific piece of evidence in your hand to run it through CODIS.
I should say
so
that
that's why
technically Kathleen doesn't have access to those databases. That doesn't mean she doesn't have a source that would. So, you never know. But
that stuff, it used to be you could have stuff run off the radar, but anymore, they've really clamped down on that. And
Connection successful.
Henry wanted to say hello. He saw
Hey, Henry.
Tracie's dog, but
yeah, Justice was crawling on me a minute ago.
So you have to log in with a specific login name that's law enforcement related. You got to enter a bunch of data, and if they catch you running stuff that's not law enforcement related, they can pull the access for the whole department. So yeah, it's kind of a bummer because we had on really important stuff we kind of wanted to check out ahead of time. We all had a source or two, but that seems to have been drying up significantly.
Right. Okay, somebody asks, let's see here. Zelma Lopez asks, who was the officer that said it was possible the key could be planted? Could he expand on his thoughts? That's Officer Kucharski. I don't think he's interested in expanding on his thoughts of how it could be planted because he was suggesting that aliens could have done it. So, yeah, although I am more than willing to listen to Kucharski come and expand more on aliens any day of the week because I will be rolling on the floor laughing while he does so. But yeah, I don't know if there's really much there to be got at factually. Let's see. Oh, Captain Crunch is back. The hood-latch DNA was simply the groin swab swabbed by Wiegert. That's how there's 90 times more DNA than there should be. Jeff Correa, let me try again. If Stephen gets a new trial, must the state's narrative not include Stephen? No, oh, must not. Okay, but must the state's narrative not include Stephen burning Teresa's corpse? Yet somehow we have bones in a burned pit. Okay, I see what he's saying. So are they really gonna? If he's been, okay, I guess what we're saying here is if he's been acquitted of that stuff, are they really going to be able to argue at trial that he burned Teresa in his burn pit if he's already been acquitted of that? I guess.
Yes, they can argue it. He just can't be charged with it.
Yeah. Okay. So
and
they
he
can
can't be
still argue
convicted
it.
of it. Yeah, they can
Okay.
argue it because there's nothing to say that the reason that the jury acquitted him was because they didn't believe he burned her in the pit. I mean, you don't know why they made that decision. So they can still argue it. He just can't be charged with it again.
Relevant evidence doesn't end at the time that the person is deceased. In other words, okay, well, you're proving the murder, you know, how is what happened to the body afterwards relevant? And it could be relevant because there's a mutilation allegation, which, you know, is now forever barred, but it's also relevant to show consciousness of guilt is the legal phrase. And so hiding a murder weapon, hiding a knife, cleaning up your house, cleaning up the garage, cleaning up a car, all those things to cover up a murder are all relevant. But that poses an interesting question. You know, if what she has to show to get an evidentiary hearing, you know, is going to be less than what it would take to get the appellate court to just go ahead and grant her a new trial right from the get-go. But that'd be nice. But, you know, to get a new trial right out of the appellate court, it's going to have to be, you know, something fairly substantial. It's going to have to be a clear Brady claim, which there's been no evidentiary hearing, so it's unlikely that they would grant that in the appellate court. More likely they'd send it back for an evidentiary hearing to explore. It's, you know, ineffective assistance of counsel. You know, you really need a evidentiary hearing for that. You know, if by some miracle, if they look at the evidence that she's laid out and they say, yeah, we believe you've more than shown that there's a lack of confidence in the verdict. You know, they're going to probably retry that case, whereas, you know, they're not going to have any alternative. Whereas if they send it back for an evidentiary hearing and she shows a bulletproof Brady claim or a bulletproof IAC claim, and they grant a new trial, they may not be interested in retrying the case. It's just kind of how you see these things run through the system, and which cases get retried and which cases don't get retried. Obviously, the clear exonerations, smoking gun DNA, like in Stevie's first wrongful conviction, you know, they don't retry those cases. But the ones where, you know, you don't have smoking gun DNA, a lot of those get retried with unfortunately similar results. And so, you know, hopefully she continues to go with her investigation and she continues to keep narrowing in on somebody, because I think if it got reversed based on what she has in her brief now, they'd retry it. And it's just going to depend where they get that case moved to. I don't think even Zellner can get a different result if it stays in Manitowoc, or they move it to Calumet County and bring over a Manitowoc County jury. But I I know minds are being changed all the time in Wisconsin, but seeing what happened with the sheriff's race in Calumet County and other things around there, I worry about that. That if you got a new trial, where would it be?
Right.
If they were smart, they'd move it to Milwaukee County. That's where they should have moved it the first time.
Mm-hmm.
You don't even have to
Right.
try hard to find people willing to believe police planted evidence in Milwaukee County. Don't even have to try hard. You don't.
Yeah.
Happens
Right.
all the time.
We've heard people from there say that. Now,
Yep.
what's the standard on a change of venue there? It doesn't really matter now. I mean,
Well-
you have to be sleeping under a rock if you haven't heard the case in
Oh,
Wisconsin.
you'd be surprised. You'd be
let
surprised how many
alone-
people in this state don't know anything about the case.
Mhm.
Lots of people. I'm related to a lot of them.
Really,
there's
really.
hardly anybody in my family knows anything about the case. Yeah, they only know about it because of me talking about it, but they don't know anything about it. And it's not as well known as people think. A lot of people, actually, Steve and I just talked about this quite a bit, is that, I would love to know what viewing statistics are for Netflix, because the first ma'am probably was watched a lot in Wisconsin because people were curious because it was a Wisconsin case. But I can almost guarantee you that the ma'am 2 viewership is way down in Wisconsin compared to other places, because still too many people here think that he's guilty. They don't even want to watch the thing. We have one of our morning show hosts
Say
had a
that
podcast.
Say that last thing
Said
again.
too many people. I said there's too many people here who still think that he did it, and they don't want to watch it because they said that they remember. They watch the news, then they know what happened. They watch the trial on TV, so they're not even willing to watch it. And we have a public figure here who did a podcast, who's a Kratz fan, and almost everybody I know that's mentioned to me about him being guilty brings up his podcast. And it's like,
Is that
and they think
O'Donnell?
that's the truth. Yep.
Okay.
Yeah. Oh God, that guy who is basically like,
even Wiegert suggested that guy to Paul Capaldi in an email.
Yeah, everybody. I can't believe my mom's friends, when my mom's brought it up to them, they mentioned, oh, well, I listen to Dan O'Donnell's podcast. I'm like, he wouldn't know a fact if it jumped up and bit him in the butt. He wouldn't. He just spews the same thing that Kratz does. He regurgitates whatever Kratz says, but he has a big following and people listen to him. And so it's sad. I wish that people felt about the case here like they do in other states, but they don't.
Right.
That's why it's very hard to get anything done here.
Right.
Well, I think that's important for all your subscribers to hear, Erekose, is that, it's really, really hard to comprehend that a lot of people in that area think those 2 boys are, in where they belong. And when you get in an echo chamber, that's not a good thing. If you're trying to seek change through a movement, first thing you got to understand is, what's the reality out there, and to get people to try and understand. But I think MAM1, the numbers hovering right at 90 million views. I don't know, MAM2, 90 million is the last I heard. People watch Netflix, MAM1.
Right.
Yeah, and I would find it hard to believe if the numbers were anywhere close to that for the second one, because like I said, I know just from looking at my own Facebook feed, a lot of people that watch the first one out of curiosity, but they won't even bother with the second one because they know he's guilty. So I don't even argue with people anymore because it's so hard. I mean, I went to the doctor the other day and the nurse there was like, she doesn't believe that Brendan, she believes that Brendan did it. She said, I don't believe that someone would confess that when they didn't do it. And then her explanation for why Steve's guilty is because her body was found there.
Right.
So
yeah, I
of course
know.
she did it.
I love it. Everybody's an expert.
Yep. And that's 2 hours away. That's 2 hours away from Manitowoc, so that's not even just in Manitowoc and Calumet, Calumet.
Manitowoc. Hey, I like
I'm starting to talk like Steve.
I started calling it that, and I got hate mail.
Hate mail.
I call it Manitowoc. I don't put it in the third syllable. I don't put it in the third syllable.
And Calumet.
Manitowoc.
Funny. Okay, so Tony Frattini asks, how will KZ be able to get the bones from the Halbach family back for the not DNA, well, DNA testing, for the quick DNA testing? So I'm going to go ahead and say one thing about that. One thing is not all the groups of bones that KZ asked for, not all of those groups had bones given back to the hall box from them. So technically there is, I believe, still like 3 groups of bones that KZ was asking for that are still there. I believe that this will probably have to get argued about in a courtroom about which bones and whether or not they need the ones that potentially were given to the hall box. Although if they weren't given to the hall box, what the hell did they give the hall box other than animal bones? But I don't know. Anyway, the point is there will probably have to be some kind of agreement reached or something like that will happen. I mean, that will be reached by the parties, I got to imagine. But since we got 2 legal minds here to give their opinion, what do you think?
I think that with a lot of stuff, we have very limited information about what exactly was given to them. And I don't see what they're going to do about it. I mean, an exhumation, if they buried the bones in a casket, can you do an exhumation? Possibly.
Right.
You deal with chain of custody issues then. It's one of those things that you just have to wait and see until we have more information before we can really even begin to make a guess of what can legally be done. They won't overturn a conviction because of it.
Right.
I mean, they won't, period.
Right.
I mean, they'll basically probably just say you're out of luck, which sucks, but it wouldn't be the first time that evidence was destroyed that wasn't supposed to be. And courts do not exactly usually like overturn convictions because of that. They just say, oops.
Okay. So Felipe Artista asks, let's say the courts agree to a new trial. Would she be able to petition for Stephen's release on bail or bond pending trial?
Yes, but it would never happen.
Right.
It'll be the 500,000 that he had before. They have to set a bond there, and because they have no capital cases there. But what was it before, Tracie? 500,000 and.
Sorry, I'm choking on my.
Oh, you're all right. Well, she has a sip of water. I think it was.
That's what caused me to choke.
Oh.
I swallowed wrong. That's it. Sorry. Talk amongst yourselves.
They'd set it real high, and his family was unable to make the high bond in the first case.
Oh, okay. I see what you mean. All right. Ms. Deborah asks, can Stephen Avery brain fingerprinting results be used in retrial? If so, would it be useful? I'd say their effectiveness might be marginal at this point in time, my opinion.
I'm still coughing, so don't ask me.
On the 8 fingerprints?
On the brain fingerprinting.
I find it highly doubtful they would ever admit that in a court of law.
Yeah, I don't think it's ever going to be admissible in a court of law. Although I did read something, maybe it was a Zellner tweet, that a court did admit brain fingerprinting for limited purpose. I don't think it was a jury trial. I think it was
it was in the Iowa court system. Harrington was the case, and it was admitted on an appeal, but the conviction wasn't overturned because of that. It was actually overturned because of a Brady violation. But I do not think that it would satisfy the Daubert standard at all, because it has not been peer reviewed, because Dr. Farwell refuses to give his method away. He will not give enough information so that his testing can be duplicated under those circumstances. And if you don't do that, you're not going to satisfy Daubert, and it won't be admissible. So even though one court did admit it, it's a long shot that any other court would admit it until that happens.
I thought more recently she did something that it was accepted at a hearing within the last month.
I don't know.
But at a hearing, and you had to go to his website, and I didn't do that. But the problem with it,
he's actually in my group, so you can tag him with a question if you want.
Yeah, the problem with it is that the examiner, person that administers the test, they still have to formulate the question. And so that is subjective. That is, and which is why polygraphs are inadmissible, is that the science behind polygraph, the machine part of it, perspiration, heartbeat, all of that can be scientifically validated. The problem is that you're asked controlled questions and the way you frame the question to get to whether the person is
telling the truth or not.
Well, being deceptive,
right,
or not being deceptive. And so it's the way they frame those questions. They spent a lot of time. As soon as I saw MAM2 and I saw what he was going through, he had to find us a question that would not trigger something he actually saw. And I'm like, they're never going to admit this under, old Fry or current Dauber. They're just never going to make this admissible because the person has to formulate a question that doesn't cause it to be invalid because of this, or to include things and include that. That's exactly what a polygraph is. And, it's just never going to get past that standard. I agree with Tracie. Or if it does, it's going to be way, way, way down the road when his patents expire, and it can be subjected to true peer review.
Correct.
Okay. So it looks like that's pretty much all the questions. Well, somebody comes up with one here. How are the bones found in the quarry? That would be by dogs. The dogs pretty much were finding those, I would think, or at least leading officers to the areas where they were for the officers to find them. But anyway, so we're going to go ahead and wrap it up for tonight. I think we had a lot of interesting discussion here, a lot of interesting points. Very good to have your guys' side of it as two legal minds, and particularly use Tracie because you're on the ground there locally. So I'm very happy you guys could be on tonight. I'm very sure that everybody in the chat was tickled to hear your guys' opinions and your guys' informed opinions about this stuff. So thank you for being here, both of you.
Thanks for having me.
Thanks for having me, and thanks for coming in, Tracie. I've been a big fan of yours on your Facebook group and try and get a question answered here and there, and you've always gotten back to me with an answer. It's usually on Wisconsin law, which can be tricky, and I don't know how you all keep up, because it'll say one thing, or it'll be a civil rule, and then it like that when you file a motion in an appeals case, it automatically stays the appeal until it's decided is actually a civil rule. But it's great having you, and I'm hoping you'll consider popping in for the premiere when we actually do that segment on Kathleen, including in her brief the 805.15 arguments. And great to finally meet you. Thank you. And thank you, Erekose, for what you do. And again, thanks to JJ, Julie, for helping us with those presentations.
Julie J.
Look so good.
So absolutely, yes. Big thanks to Julie J for her help. These slideshows have been absolutely phenomenal. When she sends them over, I look at them and I see all the pictures and imagery she used, and I just think they're brilliant. So yeah, absolutely, big thanks for her. And if you haven't already, please hit subscribe. And of course, on the way out, we're going to listen to a little Stacy Seabrook.
Denise put up Tracie's Facebook page. Thanks for doing that.
Yes,
thank you. I'm on YouTube, but I really don't. I don't advertise it. I like to do the live videos in my Facebook group so I can answer questions in real time. Yeah, and then the only reason I did YouTube is so I can share it outside the Facebook group. That's it. But you can subscribe if you don't want to go on Facebook. You can subscribe to my channel. But
it's a good place you want to go. But hey, You can go ask questions and make sure they're legal questions, folks. Don't go in there with Teresa Alive crap or anything like that. She will boot you out on your.
I will not boot somebody for that, but I will not
Legal
accept the
questions,
question.
Really, seriously.
Legal
Okay,
issues
I'm
only.
exaggerating, but still.
Yeah.
All their claims so blatantly get torn to tatters.
I think it matters.
I bet you heard about her last sweat, but maybe you ain't heard this yet. 19 more times the DNA that was left anywhere else that day. I think that matters. I really do. I think it matters. An ex-boyfriend with a day planner page, and yet they did not investigate. And who knows why, and who can say why he was signed into the crime scene that day. I think that matters. I really do. I think it matters. About the barrel that once was seized, but then returned to the Averys. The bones were found the next day, but not one photograph exists of where they lay. I think that matters. I really do. I think it matters. I could go on listing things off, 80 more things. I just keep on singing these songs till every freedom rings. I said it matters. It really, I know it matters. It could be you, I think it matters. It could be me, I know it matters. Work with Casey, it matters. I said it matters. It really matters.
One more.
Since 7 a.m. now here I go again to confine innocent men in a 10 by 10. All fates, oh, neither men deserve. But fear breeds silence in Manitowoc. You don't say nothing 'cause you know your cops, but someone knows something. Yet everyone plays ball. I say we round them all up. Let's brain fingerprint them all. Everything about the case it was suspicious. I hope the Biden teeth of justice are so vicious. For those who read the lie, they temporarily preserve. From time into time, both the Brendan so-called confession to the fact that Peterson was out of town when she went missing. How can we forget Andy and William Henry Call? I say we round them all up. Let's brain fingerprint them all. So much planted evidence now anyone can see. The magic bullet blood in the RAV. And even evidence that defies gravity. The key that turns up 7 searches later with none of her DNA at all. Let's brain fingerprint them all. I say we round them all up. strings, I wanna know that top rank. For those who pay attention on the unbanked stank. Those that are smiling, they always know who would take the fall. I say we round them all up. Let's brain fingerprint them all. I say we round them all up. Let's brain fingerprint them all.
All righty. Thank you, everybody. Remember, hit subscribe, and we'll see you next time.